of your kids. Hi, I'm attorney Michael Potter, and in this segment we're going to look at the options that you've got for planning that will not only provide for the security of your kids, but to give you tremendous peace of mind. One of the easiest things that you can do that will provide for security is to make sure that your life insurance is up to date and that your beneficiaries are properly named. You don't want the life insurance contract to pay to your children as direct beneficiaries, because that would result in a conservatorship and the judge would be in charge of your children's financial lives until they turn age 18. Instead, leave the money to a life insurance trust. If you name a life insurance trust to receive your life insurance death benefit, then the children avoid the necessity of conservatorship or probate, and you don't have to worry about your children's creditors or ex-spouses or future legal adversaries getting a hold of the funds. Next, take a look at disability insurance, because your ability to earn a living is probably one of your most powerful assets. It affects everything that you do and certainly affects the security of your children. Take the time to look at different kinds of disability insurance so that if you can't work, that money will still be provided for. Next, name legal guardians for the kids. That's the person who is going to raise those kids if something happens to you. And just to be on the safe side, I recommend naming a first choice, a second choice, and a third choice. The legal guardian will have the responsibility to raise the kids and provide for their care, support, food, and shelter until they are age 18. So think carefully about who you want to choose. Consult with them, and if they agree to it, then go ahead and name them in the context of your last will and testament. Now, if you decide to remarry, be sure and get the guidance of an estate planning attorney who will help you establish an estate plan that makes sense, that even if you want to provide for your new spouse, ultimately, you want the assets that you've accumulated over time to go to the children. So plan it that way and draft it properly, probably using a living trust along with a pour-over will that names a guardian for the kids, but provides through the living trust for the sake of your children. Next, you want to be sure that you have the proper health care documents in place. And I'm thinking primarily of two things. Number one, the power of attorney to make health care decisions. And number two, the advanced health care directive that has to do with artificial life support. Now, as to the power of attorney for health care decision making, this can be very important and very crucial. So if you're going to name the children as having that power of attorney and be your agent for health care decisions, make sure that the person you appoint, if it's one of your kids, is old enough to be able to legally make those decisions at 18 or over. And number two, that they have the emotional maturity to be able to handle it, because frankly, it may be quite challenging. And then I would name not only a first choice, but a backup choice, a second choice, a third choice, and so forth. I think that that would give you more peace of mind and provide for your healthcare decision making in a context that's reasonable and sane. Now, as to the healthcare directive on artificial life support, sometimes this is referred to as the advanced healthcare directive, and it provides for a specific type of medical situation, one in which a decision could be made to save your life. And basically what you're saying with this decision in the document is, if you can save my life, great. But if all that it does is merely to prolong the moment of my death, don't do it. This relieves your family of having to make a tremendously difficult decision at probably one of the worst emotional periods of their entire life. So save your children from having to make that decision, and you make it in advance in the Advanced Healthcare Directive. Now, if you have any type of retirement account, an IRA or 401k, etc., definitely check with your attorney and with your account custodian. There may be some documents and waivers that you need to sign to make sure that your prior spouse is not the recipient of your retirement account in the event of your death. I would recommend, for the protection of yourself and your kids, that you have a retirement inheritance trust be the recipient of your retirement account. Not only will that protect the money, but it will allow the children to receive it over their lifetime, and it may very well grow over the period of their lifetime. We cover that in a separate segment, and I hope you'll take a moment to watch it. Finally, one of the best things you can do for your children is to leave them a video that sets forth your hopes and dreams for them, that talks about your best memories of them as little toddlers when they were so cute, and your best memories of them growing up and how proud you are of them. Address their best character traits. Encourage them to live their life by those character traits and to be an example for their own children as they grow up. You'll find that a video like this will always touch their hearts, soften their hearts, and give them a tremendous sense of inspiration from you as their parent. What a loving gift. That's something that you can give your kids that is so much more valuable than any monetary gift you might ever leave them. Well, as usual, I've given you a lot to think about, and you may have some questions or you may want some guidance. I'd be glad to help you at any time. I'm Michael Potter, and I look forward to hearing from you.